about statute of frauds? The statute of frauds doesn't especially have anything to do with fraud. It's not the same thing as suing for fraud. Instead, it was a statute that came about during the development of common law. And the idea was to prevent fraudulent or the enforcement of fraudulent claims. The idea was that some contracts are so important that you would have written something down, and if nothing was written down, it kind of makes you suspect whether there was ever an agreement in the first place. So what courts said was, we're going to include a few categories of contracts which, if there's no written proof that there was ever an agreement, we'll simply refuse to enforce them. And that statute is called Statute of Frauds. The statute requires that certain contracts need written proof. Now again, I want to be careful not to confuse you. Most contracts do not normally need to be written down. So the Statute of Frauds does not apply to most contracts. There was a pretty famous case a few years ago where actress Kim Basinger agreed to be in this horrible movie. I saw part of it called Boxing Helena. Apparently she had orally agreed to be in the movie and thought better of it and changed her mind. And she thought, well, I don't have to do it. I didn't sign anything. Well, if Kim Basinger had talked to me before she made that decision, I could have saved her a bankruptcy and a $9 million judgment, because that's what happened. Most agreements are enforceable, even if they're not written down. It's certainly harder to prove an agreement if there's nothing written down. But if you can prove it in general, it's enforceable. So Statute of Frauds is the exception to the general rule. Under the Statute of Frauds, if a contract falls within that statute, it does need a writing. What's a writing? A writing is not necessarily the contract itself, although that certainly would suffice. Instead, a writing is something sufficient to show evidence of a contract. I hope you hear the difference. We need written evidence that there's proof of the existence of a contract. So be careful. There has to be enough written down to show that there was a contract, and secondly, there has to be enough completeness that a court could figure out what the parties had agreed to. This would normally include the names, the subject matter of the agreement, the terms, the price, and the signature of the party refuting the contract. So you don't even necessarily need all the parties' signatures, just the party saying that there wasn't an agreement. One good rule of thumb in determining whether there's enough completeness to enforce an agreement is pretend you're the judge. If you were the judge, could you interpret what the parties meant? If the answer is yes, then there's probably enough completeness for a court. Let's take a couple of hypotheticals. Number one, suppose two parties are discussing by phone the purchase of a factory, including the building, the land, the equipment. At one point, one of the parties, Joe, says, just so that we can get the details straight, would you mind if I record this? The other party, Shauna, agrees. Later, Shauna denies there was an agreement, and Joe seeks to introduce evidence of the telephone recording. Issue: can a tape recording be a, quote, signed writing within the Statute of Frauds? Well, think back to when we discussed the interpretation of cases. Go back to what's the legislative purpose of the Statute of Frauds. It's to prevent fraudulent claims. Would that purpose be furthered if we allow a tape recording of the parties? In other words, would it be functionally the same as allowing in something Shauna had written and signed? And in this case, the court said yes. A tape recording under those circumstances could be substituted for a writing because it does show what the parties are alleging was agreed, and you are getting Shauna's voice. Some people argue, can't you fake a voice? Well, of course, and you can fake a signature too. A court will always look to see whether evidence has been tampered with. But at least here we have evidence of what Shauna said. And if that's relevant to whether they intended an agreement, a court may say a tape recording is a substitute for a writing or as good as a writing. Hypothetical number 2. Rodrigo agreed with Armin to sell gravel at a certain price and quantity. Armin wrote the details on the back of an envelope, including the language, quote, contract to follow, end quote. Rodrigo signed it. Later, Rodrigo denied there was a contract. There were two issues here. The first issue was this sufficient to demonstrate the existence of an agreement in light of the language contract to follow? Because you have to remember that you have to what you have to show in writing. You have to show not just that they discussed the possibility of an agreement, but that they agreed. Contract to follow. Does that mean in the future we might agree on something, or today we agree on something and a formal document will be sent out later? The court concluded that it was the latter, that the parties really had agreed that day when they wrote on the back of the envelope, and the fact that they were going to send the formal writing later didn't negate the fact that their agreement didn't occur that day. Issue number 2 is, was there a signed writing since only Rodrigo signed the envelope? Remember, you need the signature of the party who's denying that there's a contract. Rodrigo is the one denying that there's a contract. So, Rodrigo, that's enough. Therefore, the court upheld this as a writing sufficient for the Statute of Frauds, indicating that there was a contract and that the court would enforce that agreement against Rodrigo. Now let's talk about a contract covered by the Statute of Frauds. Again, and not to be too tedious, but the Statute of Frauds does not apply to most contracts. There are several categories to which it does apply, but only 2 categories come up very often in business. Therefore, I ask that you read the whole chapter, but I'm only holding you to understanding these 2 categories. The first category is the sale of an interest in real property. It excludes short-term leases, and by short-term, they mean less than or equal to 1 year. So leases of 1 year or less are not included in the Statute of Frauds. Consider what we mean by an interest in real property. We tend to think of it as, do you own something? Do you own that building? That would certainly be an interest in real property. For example, I own my house, so I have an interest in real property. But there are other people who have an interest in my house. Who else does? Well, the lender does, because I borrowed a mortgage on that house, so the lender has an interest in the property. There's an easement on the back of the property because there are utility lines, and the utility company has a right to enter my property and service the utility poles. So I'm not the only one who has an interest in that property. So think more flexibly about who has interests in real property. Let's talk about the first hypothetical. A borrower met with a bank loan officer about being in default on their mortgage. Orally, the bank officer promised not to foreclose. Later, the bank officer did attempt to foreclose despite the loan officer's promise, and the borrower raised that oral promise as a bar to foreclosure. In other words, you can't foreclose on me, you agreed you wouldn't do that. Issue: could the promise be binding since it was not in writing? Did such an agreement fall within the Statute of Frauds? Did the bank, which had loaned money to finance the sale of the mortgage, did they have an interest in real property? Yes, the bank has a security in that property. Did this agreement fall within the Statute of Frauds? Yes. Is this an agreement to promise not to foreclose on you? Possibly so, but tough luck. You didn't get anything in writing from the bank. And therefore, even if you can prove that the bank officer orally promised you, it's simply not an enforceable promise. The second category of contracts covered by the Statute of Frauds, for which I'll hold you responsible, is the sale of goods worth $500 or more. We've talked about the distinction between goods and services. Goods are things that are designed, grown, manufactured, packaged, distributed. Distinguish them from services. So this provision covers the sale of goods only. This provision, originally common law, is now encoded in the UCC, the Uniform Commercial Code, Most of the UCC covers only merchant-to-merchant transactions, as we saw previously, but not this provision. This provision applies to all parties, even if they're not in business. So you're looking for any contract that involves the sale of goods worth $500 or more. You are excluding contracts related to services. Let's try a hypothetical. Suppose a consumer enters a contract with a painter to paint his house. The value of the materials alone is $1,000. The total contract price is $8,000. Does the contract fall within the statute? If you answered yes, you are both logical but wrong. You're logical because the value of the materials alone are worth more than $500. However, this provision of the Statute of Frauds applies to the sale of goods only when they're being sold by themselves. When a painter's going to come and paint your house, you're buying both the goods, in other words, the paint, and also the services, and therefore it does not fall under the Statute of Frauds. We're talking only about the sale of goods. So now that we have the provisions relevant to the Statute of Frauds, let's talk about defenses to the statute. One defense would be part performance. This part performance, if you think about most contracts, the agreement is separate from actually performing the agreement. So let's say I agree to sell you my car for $10,000. I made an offer, I'll sell you my car. You accepted, you said you would pay me $10,000. We have a promise, I'll sell you my car, in exchange for another promise, I'll pay you $10,000. This is a bilateral contract. Have we performed? Well, not yet. What do we have to do to perform? Well, you have to give me $10,000 and then I'll transfer ownership of the car to you. That would be performance. What if a party partially performed a contract? What if the contract falls within the Statute of Frauds, but there's no writing? However, they've partially performed the contract. This could be a defense to the Statute of Frauds. If the contract is related to an interest in land and the would-be buyer paid for the land, but there's no evidence of an agreement, this will not be enough for a court. Otherwise, I could send you a check and say, oh no, we had an agreement. You're going to sell me your great house in Bel Air for $100,000 and I sent you a check. The court is going to say on that one, no, that's not enough. However, if a would-be buyer paid for the land and made improvements on the land, that tends to show that there must really have been an agreement. This goes back to the policy of Statute of Frauds. We're trying to prevent fraudulent claims that there's a contract when there wasn't. It's unlikely that you would have made all these improvements on the property unless you had a contract related to the property. So the court may allow part performance as a substitute if you've made improvements to the land. Part performance with regard to the sale of goods under the UCC, so that if the contract falls within the statute but there's no writing, the contract may be enforced up to the limit of performance but not beyond. So if the sale of the goods is over $500 to the point where one party actually performed, the court may. Part performance with regard to the sale of goods under the UCC, so that if a contract falls within the statute but there's no writing, the contract may be enforced up to the limit of performance but not beyond. So if there's an agreement for the sale of goods over $500 and partial performance, the court may enforce it up to the level of that performance, and the other party must pay. The court may not enforce the entire agreement if they actually agreed to buy more goods, only up to the degree of the partial performance. What about specially manufactured goods? In that case, courts will enforce such agreements even with the lack of a writing. I can think of one example of that. Let's suppose that you're a shower door manufacturer and you enter a contract with a hotel. Let's just say it's a Hilton, although in the actual case it wasn't a Hilton hotel. You had an oral agreement that you would manufacture 350 shower doors with Hilton etched in the glass. These are specially manufactured goods. Obviously, no one has any use for a shower door that says Hilton etched on it, except for Hilton. So, because there was no written proof of this agreement, and Hilton was saying there never was an agreement. Is it likely, and again, we're trying to prevent fraudulent claims, that a business would create hundreds of products good only for one customer unless there really was some kind of an agreement? It's just unlikely that someone would do that, and therefore, for specially manufactured goods, contracts might be enforced despite the lack of a writing. The third defense with regard to the sale of goods category is that if the other party admits there's a contract despite the lack of a writing. So if the other party said, yeah, there was an agreement, but we didn't write anything down, however, there was an agreement, then it can be enforced against them. Finally, let's talk about merchant silence. This applies only in merchant-to-merchant transactions, but if one, and again, a merchant is someone in business, if one business person sends another business person a confirmation, in other words, this is a confirmation that you've ordered these goods and we're going to manufacture them and ship them to you, and here's the price. If the other party doesn't object to that within 10 days, then a contract can be enforced. Again, go back to the purpose of the Statute of Frauds. We're trying to prevent fraud, not permit it. What would you do in business if someone sent you a confirmation, but the whole thing was false? Wouldn't you say something like, I don't know what you're talking about? So the fact that you did not say that, you were silent, tends to confirm that there really was an agreement. So, those are the 4 defenses to the Statute of Frauds with regard to contracts for the sale of goods. Okay, now let's take a hypothetical. Suppose that 2 merchants orally agree that one will sell steel fabrications on a 3-stage delivery schedule with a price of $6,000 per delivery. The first delivery was made and accepted, but now the recipient is denying any further liability. What result? Well, is this a contract that falls within the Statute of Frauds? Yes, because it's the sale of goods, steel that has been fabricated, and it's worth more than $500. So yes, it falls within the Statute of Frauds. Is there a writing? No, in this hypothetical, there's simply an oral agreement. Is the contract enforceable? The general rule would start you with, no, it's not. However, there is part performance here. One of the deliveries was made and accepted. Will a court enforce the entire contract? No, there's part performance. One of the 3 deliveries was made. Therefore, the court will enforce one payment for that one delivery, in other words, $6,000, but they will not enforce the entire agreement. The remaining 2/3, the remaining 2 deliveries, there is no contract for that which is enforceable by a court. So the steel fabricator gets $6,000 and that's it. The rest of the agreement is not enforceable. That concludes our discussion of the Statute of Frauds.